witnesses, and I'd like for them to be up there. And
Very fine, sir.
When I testify, I'm going to go up there.
All right. Thank you, sir.
First of all, I'd like to thank members of City Council for their service to the city. I know it's a tough job. I actually had an employee who sat on City Council. I know he actually spent more time on this job than he did on his job for me, so he didn't last very long. But I know how much time it takes.
With you or with us?
He didn't last very long with you either. But I know it's a very, very time-consuming job, and I think that this appeal goes way beyond the parties that are here today, because it's a very important issue that you're going to see again and again coming up in the Ocean Drive, Sexton Plaza area. My understanding is that there's an application right now before Planning and Zoning Board for a change in outside dining for the Vero Beach Hotel. So this is something that is going to have far-reaching ramifications for everybody in the city. And I'm putting up here a picture of a summer day. This is a summer day in Vero Beach. That's the north side of Sexton Plaza. Just imagine what it's going to be like during the season. Now, this appeal was brought by a number of, we call them aggrieved persons because that's what the statute requires us to call them, but they're actually business owners, property owners that have businesses in the area. Kathy Paget, who owns the veranda and the property located at 3325 Ocean Drive, and she's here today in the front row. Nancy Cook, who's represented by Leslie Gordon, who's here in the front row today. That's the owner of the Twig, and also the property located at 3213 Ocean Drive. Charles Rapogle, who's the owner of the Ocean Grill, and Mark Tripson, who's the owner of the property on which the Ocean Grill is located, and me. I am here today as a property owner. I'm not here as a lawyer. I'm not representing any of the appellants here today other than myself, and I'm not getting paid for my time today either, because I'm here as a property owner that's concerned about the future of Vero Beach and the very large parking problem that we have right now. Despite what Mr. McGarry says, I think that there are a number of different ways that this council can reverse the decision of the Planning and Zoning Board. It's not just a matter of staff's misinterpretation of the statute, which I believe is a very important point, but there's also the failure of the Planning and Zoning Board to properly notify the adjacent landowners that the application was after the fact rather than a proposed addition. And we're going to have testimony about that today. Also, the staff's misinterpretation of the parking regulations to totally exempt outside dining from off-street parking requirements, and the misrepresentation of the law to the Planning and Zoning Department and the public. As I've brought out in Mr. McGarry's testimony or cross-examination today, Planning and Zoning Board didn't have a copy of the statute. All they had was a copy of what Mr. McGarry says the statute is. And if you look at that statute closely, which I'm hoping you will today, you'll see that it's not consistent with Mr. McGarry's interpretation. The third reason is the failure of the owner to approve the site plan. We've already gone over this in Mr. McGarry's cross-examination. The Vero floor plan is not the same as the site plan. There's substantial differences, and the owner is required to approve the site plan. It would be ridiculous if the owner was not required to approve the site plan. And the fact that there were Planning and Zoning Board meetings and the owner didn't show up is no excuse for the site plan to be different than the plan that was approved by the owner. Also, the 1967 parking agreement is an issue. If the Holiday Inn does not allow patrons of Mulligan's to use their parking lot, there is no reason the city should have to be bound by that parking agreement. And lastly, there is a huge negative impact on the adjoining businesses. And since the purpose of the site plan approval is to protect the interests of the adjoining business owners, that is not something that could be ignored. And although staff thinks that there's no significant impact, I think the people that are sitting here today will testify that there is. So first of all, first base is inadequate notice. And I'd like to call Charles Rapogel to testify.
Hello.
Mr. Rapogel, would you state your name and your address?
My name is Charlie Rapogel, and my home address is 105 Sandpoint in Vero.
And are you a business owner in Vero Beach?
Yes, we are. Our family has leased the Ocean Grill restaurants for 49 years.
And can you tell me how you became aware of the changes that were being made to the outside of Mulligan's and what you did about it?
Well, we noticed probably parking was really getting difficult during the season. It was the worst we've ever seen in terms of our customers, even with our own parking lot, being able to find spaces to be able to park their cars and come in and dine. And it was like that across the board from Ocean Drive to Sexton Plaza. But I had noticed probably a year prior to March that the Tiki Huts tables that had been put up at Mulligan's, there were at least 5 or 6, plus the Adirondack chairs were there and being serviced, full serviced, which requires wait staff, bus boys, the whole 9 yards. So regardless of whether it was inside or outside, it required, in my mind, parking, not only for customers but for employees as well. It was my assumption, because I've seen the city act before, that the city would have had to have noticed this. This is not behind closed doors. But it was there, and it had been there for about a year. So I picked up the phone and called Monty Falls and said, "Hey, Monty, what's up with the extra seating at Mulligan's?" And so he referred me to Mr. McGarry. So sometime in the spring, I don't know whether it was at March or April, I called Mr. McGarry, and I said, "I don't understand how this additional seating can be placed in front of Mulligan's without additional parking, and where's the parking?" And he explained to me that at some point in the future, he didn't know when, there was going to be some sort of public hearing about this. And I said, well, we would certainly like to participate in that, and we would like to know when that would be, and we'd like to get some sort of notice so that we can prepare ourselves for it. So we asked him if he could at least give us a let know when this was going to happen, so that we would be able to prepare for it accordingly and voice our opinions and objections about it. The parking at Sexton Plaza, even to this day, even in the off-season, like on Saturday, we did our own civil engineering count, which is my parking lot attendant, who's been there for about 25 years. We counted over 180 cars that circled Sexton Plaza in 1 hour, from 11:30 to 12:30. 25 of those actually came in and parked in our parking lot and went into our restaurant. But all the additional cars were looking for spaces because the Sexton Plaza was full on a Saturday in October. So anyway, we waited and we waited until we did not hear anything about a public hearing. We were not notified about any questions that we might have about it, additional seating at Mulligan's. So I was out in Wyoming at the time. My son was managing the restaurant, and he said about August 1st, he said a customer came in and said that there was a public hearing going on about Mulligan's and the additional seating. And I said, well, wait a minute, how come we don't know about this? And that the hearing was on, I believe, August 7th, and so I told my son to call Mr. McGarry, and Mr. McGarry said that there was a public hearing and that notices went out, and but apparently they only went to the landlords and not the tenants, even though the tenants are the ones that have to deal directly with the parking. So, and Mr. McGarry was quite brief with my son, so I picked up the phone and asked Monty Falls to please have Mr. McGarry give me a call. So he called me within about 5 minutes and stated to me that the staff had decided that the seating was allowed because it was outside dining, and that it was pretty much already a done deal. And he basically told me that, even though, I said, well, we're going to come to the planning and zoning public hearing meeting anyway, and which we did, and we were able to convince one planning and zoning member that this at least needed to be tabled until there was further discussion on it in regards to the parking. Unfortunately, we lost the vote 4-1, and so here we are. And we still don't understand the logic behind it. Roof or no roof, additional seating requires additional parking. There's, particularly if you're going to provide full service. So apparently that's Mr. McGeary's interpretation of the rule, that there shouldn't be any extra parking, and we're sort of dumbfounded by the whole deal. And so we're just here to express our opinions, which we really didn't have time to do for the first public hearing. So.
Now, could you take a look at the screen up there? Did you receive a copy of that letter?
No, we did not.
Did you receive any notice?
Nope.
No notice from the city?
No, we eventually called Mr. Tripson, who manages the Sexton properties, for us, and when we called, he had, which was probably around the 1st or 2nd of August, I don't know the exact dates, he said he did get something in the mail. But he hadn't gotten anything when we called him.
And has the expansion of Mulligan's had an effect on your business?
Yeah. I mean, when you add 35 to 50 seats, if you take those 7 tiki tables and multiply by at least 7 people that could fit on them, plus the Adirondack chairs, there's no way that all those people are walking up from the beach or pedestrianly walking in. They're using parking spaces. So we've had to hire a security guard during the day, Monday through Saturday, to protect our parking, which we've never had to do in the history, at least in the summer, of the 49 years that we've been there. We have effectively blockaded the entrance to it on Sundays when we're not open for lunch, because I'm really not interested in catering to Mulligan's parking. And that's what would happen on Sundays if we allowed free space to happen. And it has just congested the area hugely, and it was already congested. And it's an issue, an ongoing issue, regardless of what happens here today. The parking issue is a very serious thing for all of us that do business over there. And, hopefully this is an ongoing thing, that we look very hard at what's going on over there.
Yeah, I have no further questions of this witness.
I'd like to cross-examine.
Sure.
You said you didn't receive a notice?
We did not receive a notice.
But your property owner received the notice, which was a courtesy notice sent out 14 days ahead. Did you notice the large posted sign out in front of Mulligan's?
No, I wasn't here.
Well,
but
I'm sorry.
I don't look at signs at other people's buildings.
It was pretty clear when that sign. It was a city sign, and that's.
Well, I think that's a little unfair for you. Do you think that I cruise in front of Mulligan's and look at all their signage?
Well, no, but it happens to be right across from you, and I'm just saying that.
Well,
you're up here to testify that you.
Now, if you'd have put that sign in front of my restaurant, I probably would have noticed.
I would have made it neon. It would be a special exception. But no, getting back to it, you're up here to testify there was no proper notice. I don't think you've shown that. I think we did proper notice, we did post the property, and I'm sorry.
Well, when I had a phone call with you specifically, you said that you would get in touch with me.
Well, I apologize if I did.
And you've apparently done a lot of informal things, so I would have thought that you would have had the courtesy to at least contact us and let us know. This is a small town. That's what it's about.
Well, I assume the property owner had gotten back to you on this thing, and I apologize.
There's a lot of assumptions on your part.
Let's not deal with assumptions. Let's deal with facts, please.
Thank you.
You're also claiming or contending that Mulligan's Outdoor Dining is added to the parking problems.
Well,
Where are you? I mean, let's see. Do you realize a lot of Mulligan's guests are also come from the hotel?
I'm sure that they do, but
Yes, that doesn't require parking, does it? It's already done. Isn't that true?
they come from all walks.
All walks.
They
That's a
come
good
by
term.
car. They come as locals.
Well,
They
I'm,
come on Sunday on motorcycles. They come on Saturdays. They are not all guests.
I understand.
of the hotel.
I didn't say they were.
So what's that have to do with the parking problem?
Well, I'm saying that it's. I don't think you can necessarily show that this outdoor dining has had this impact. I mean, there are a lot of. This has been a very. Don't you agree? This was a very good year for everybody, for your business.
Well, it doesn't mean that we can just randomly add extra seats.
Let's not get into a debate back and forth. Again, facts. Stick to fact, please.
Okay. Do you, that beach gets a lot of beachgoers too, don't they? Don't they park there at the?
Most of the beachgoers there are young kids doing skimboarding. Then they're parking. Their parents usually drop them off, but it does get it because it is at the end of Route 60. It probably gets a little bit more activity in regards to that. But that a majority of those people are also looking to stop and get something to eat, and there isn't enough parking. Because, and in addition to adding these extra seats, without adding additional parking, it's put an exceptionally more pressure on the whole area.
I have a question which has nothing to do with this probably, but it's just informational. How many parking places do you have in the lot that you privately own?
You know, I was
glad you
I was
own.
afraid you were going to ask me that.
Your estimate's okay.
I would have to go back and count them. I could give you an answer in an hour. I don't know. What do you think? 80?
That's good enough. Let's
Okay.
not bother counting.
All right.
Would you like to tell us how big your restaurant is?
Square footage wise, I believe it's about.
And that's everything. Kitchens. The whole
Yeah. I know. 9,000 square feet, I believe.
Well, I think simple math will show you're a little short of parking spaces,
Well, that may
and
very well be.
that's true.
Okay. Questions from counsel, please, of the witness.
All right. Thank you.
Are there any questions from the floor? Mr. Lauer, continue with your case, please.
Yes, as you can see from this letter that we received, and I'm testifying now as opposed to being an attorney. It says a proposed addition, and I think there were a number of people at the Planning and Zoning Board who thought that that was a new proposed addition, not a proposed addition. Proposed addition to me means something that you're going to do in the future, not something that's already been done. And if you look at the staff memo here, and this is the staff memo that was prepared by Mr. McGarry for the Planning and Zoning Board, it clearly says there that it is an after-the-fact approval, that the owner has already done the improvements, and I don't know how that would go into the category of proposed addition. So it's our argument here that the notice was inadequate. We brought that up with the Planning and Zoning Board, and Mr. McGarry said it doesn't matter because they've already been approved, and so the Planning and Zoning Board went along. You can read that part of the meeting. It's the very last page of the Planning and Zoning meeting. You have no choice but to approve this because they've met all the requirements. I think that we're going to show today that that's not the case, mainly because of the staff's misinterpretation of the parking code. And this is the type of stuff that was given to the Planning and Zoning. It was not a copy of the statute. It was not a copy of the municipal code. It was Mr. McGarry's interpretation of the municipal code, which I think is pretty severely lacking as far as logic is concerned. Now, if you look at the commentary, this is something that Mr. McGarry included in his materials. And I'll read this for you. Outdoor dining in retail areas approved under a site plan would have no parking requirements except for areas with more than 200 square feet under cover. Well, that to me means that there is a parking requirement. In most cases, it doesn't make a distinction between dining under cover and outdoor dining. It merely says that except for areas of more than 200 square feet under cover, that would, at least if I was sitting on the Planning and Zoning Board, mean that there is a parking requirement for outdoor dining, not that it's exempt from outdoor dining. And the commentary is confusing since there's no distinction made between dining outside under roof and dining not under roof. And it appears to say that there's a requirement for off-street parking if the area of outdoor dining is greater than 200 square feet under cover, whether the area is covered or not. So once again, it's important to look at the statute, not Mr. McGarry's interpretation of the statute, but the statute itself. And the first thing that we want to look at is the intent. As I pointed out in Mr. McGarry's cross-examination, there's nothing in here that says it's our intent to encourage outdoor dining. To the contrary, it's talking about public safety, the capacity of the roads, potential adverse impact on adjacent uses. Very important. Not even considered in the staff report, not even considered Planning and Zoning. As you can see from their minutes, we're told you can't even consider the adjacent uses because they've met all the requirements. So why even have 6301 in the statutes? It's important to note what the municipal code says, not merely what the staff thinks. The courts in Florida have been asked on numerous occasions to consider and interpret municipal ordinances. And this process is called statutory construction. And as an attorney who has had over 37 years of practice in the state of Florida and also with certifications in wills, trusts, and estates and in tax, I have had extensive experience in interpreting statutes, not only Florida statutes, but also the Internal Revenue Code. And this part of the presentation has to do with the statutory construction of not only 6301, but also 6302C, which is the most important statute or ordinance that we're looking at here. Now, the landmark case in Florida that deals with statutory construction is the Rinker material case that was decided by the Florida Supreme Court in 1973. And in this Rinker case, the Rinker company went out and after a meticulous search of all kinds of property in South Florida, they located an industrial park in the city of North Miami with the intention of building a batching plant. And the batching plant is where you mix water with the other materials and you put it in a truck and they take it to the site. The municipal code in North Miami had 43 zoning uses that covered the gamut of industrial uses. Number 29 was contractor's plant and or storage yard, which provides area enclosed by a building or by a wall not less than 6 feet high. Now, after Rinker bought the property, the municipal code was changed to exclude cement products such as concrete, block, pipe, etc. And when the zoning director denied Rinker's plan to build this batching plant, the case went through the courts and ended up in the Florida Supreme Court. And the Florida Supreme Court said specifically, municipal ordinances are subject to the same rules of construction as state statutes. Words or phrases may not be inserted in municipal ordinances in order to express intention that do not appear. unless it's clear that the intention was inadvertent, and a court must give to an ordinance the plain and ordinary meaning of the words employed by the City Council. When words used in an ordinance are clear and unambiguous, other rules of construction and interpretation are unnecessary and unwarranted. So in that case, the court ruled that cement products such as concrete blocks, pipe, etc., is different from cement, which is a substance in soft state. And the change in the ordinance that banned cement products would not prevent Rinker from using the property as a concrete batching plant. Now, another case that's even more directly on point is the Town of Longboat Key case that was decided by the 2nd District Court of Appeals of Florida in 2012. And in that case, Key applied for a development order to expand Longboat Key Club. And the development order was heard by the Planning, Zoning, and the Town Council, who determined that the application violated the town's zoning code. And after Key Club went through the process and obtained a code amendment, the City Council approved the development order over the objection of the Planning and Zoning Director, who said it didn't meet the code. And the decision of the Town Council was appealed to the Circuit Court, and then it went up to, well, actually the Circuit Court reversed the decision of the Town Council, and then the town took it to the 2nd District Court. And the town claimed that the Circuit Court erred by not deferring to the town's interpretation of the code. And in support of their argument, the town cited its long-standing tradition allowing similar non-residential development. In other words, this is the way we've been interpreting this code forever, and consequently, we've got to interpret it in this case, regardless of what the statute says. Now, the court cited Rinker and noted that the language in the ordinance was clear and unambiguous and conveyed a clear and definite meaning. And in that case, there's no occasion for resorting to rules of construction or interpretation, since the statute must be given its plain and obvious meaning. The court noted that while greater weight must be given to the administrative construction of a statute by the officials charged with its administration, a court cannot afford such deference when the interpretation is unreasonable or erroneous. And the town's long-standing interpretation of the code cannot tie the Circuit Court's hands. And this is the important part. To allow such a result would support a shifting sand approach to code construction that would deny meaningful judicial review of local quasi-judicial decisions. The meaning of a code would remain in flux. Such an approach does not promote consistency in the applicable law. As the wording of its laws bind the legislature, the town is bound by the wording of its code. This mounts a bulk work against the town's unfettered exercise of its power. The city is bound by the express terms of its ordinance. If the city desires a different meaning for its ordinance in the future, it may amend, modify, or change the same by legislative process. And the 2nd DCA held that the development order should be overruled. And the final case I want to mention is the Raymond James case that was decided by the Supreme Court in 2013, in which the court noted that another important tenet of statutory construction is that the court must be given significance and effect to every word, phrase, sentence, and part of the statute, if possible. And words of a statute should not be construed as mere surpluses. Okay, so back to 63.02C. Now, Mr. McGarry has already acknowledged that subsection 2 is the section that deals with outdoor dining under cover. But he says that Section 3 does not apply to outdoor dining that's not under cover. But it says the number of off-street required parking spaces shall be calculated based on the following: outdoor uses and sales pursuant to Section 63.04. So outdoor dining is an outdoor use. So you have to go to 63.04 in order to determine what the parking requirement is. It doesn't say outdoor dining is exempt or outdoor dining or retail display areas are exempt. That's what Section 2 says. It says temporary or permanent covered spaces, such as an arcade, awning, porch, building, overhang, or similar structure attached to the building approved under site plan for dining or retail display areas, except that the first 300 square feet shall be exempt. If the City Council wanted to say that outdoor dining was exempt, could have said outdoor dining is exempt, just like it did in number 2, but it didn't. It said outdoor uses and sales pursuant to 6304. So if we ignored 6304 in this case, we would be ignoring the words of the statute, which the Raymond James Court said we can't do. We've got to consider every portion of the statute. Now we go to 6304, and I'm sorry for the small type, but I tried to highlight some of the things that distinguish the statute. Mr. McGarry says, well, since outdoor dining doesn't involve floor area, then it doesn't have a parking requirement. But that's clearly not what 6304 says. If you look under residential uses, square footage, floor area doesn't have any meaning. It's per unit. If you look at golf courses, that's an outdoor use. It's determined by the number of holes, 4 spaces per hole. Everybody brings their own car to the golf course, and you've got 18 foursomes on the golf course. Public parks and outdoor recreation. How much outdoor can you get than that? 2 spaces per gross acre. Public or private boat ramps, 6 spaces per ramp. Those are all outdoor uses. And Mr. McGarry's argument that since there's no square footage in this outdoor dining, there is no parking requirement falls short, because 6303C3 requires us for outdoor uses to look to 6304. And the only section that we get pointed to for dining is restaurants. So in this case, we're looking at a restaurant with a 4 COP alcoholic beverage license without the SRX modifier, 1 space per 75 square feet of floor area. So since 475 square feet is under roof, 2,805 square feet is outdoor uses, and applying that multiplier, 75 per 1 space per 75 square feet of floor area, 38 spaces are required to meet the requirements of 6304. Therefore, the total required parking is 92 for the hotel and accessory commercial, 3 spaces for the outdoor dining under roof, and 38 spaces for the outdoor dining, for a total of 138 spaces. And since staff has calculated the total to be 99, the applicant is lacking 34 spaces. Now, we've already gone over this failure of the owner to approve the application in Mr. McGarry's cross. I'm not going to spend a lot of time on it, but the site plan application says see attached. The letter of authorization makes specific reference to the floor plan attached here too, which was not given to planning and zoning. I had to ask for it in order to give it to you here today. And there's the Vero floor plan. Does this look like the site plan? That's up to you to decide. Doesn't look like it to me. Looks like a whole different thing. So the owner did not approve the site plan. Now, the other thing that we're concerned about here is the mainly the parking policy of the Holiday Inn and how this voids the parking agreement. We've already looked at this under Mr. McGarry's cross-exam. I'm not going to spend a lot of time on it, but this is an agreement that was entered into in 1968 by the City Council. It's an incredible exception to the parking requirements. We're adding on top of this the additional benefit of getting off public parking, which was just put into the code a couple of years ago. And we're also being told by Mr. McGarry that regardless of the way the Holiday Inn treats its tenants, and treats its guests and treats its employees, we're still subject to this agreement. So if the Holiday Inn says no employees can park here and no guests of Mulligan's can park here, only guests of the Holiday Inn can park here, the city is still bound by this agreement, and we have to give them additional spaces for the change in the code in 2011. That is a ridiculous interpretation of this agreement and of any type of a statute. And that's the end of my presentation. I'm going to call some other witnesses, so I'd be very happy to answer questions or be cross-examined.
Questions from council, please, of Mr. Lauer.
Yeah. I'd like to cross-examine.
Proceed.
Okay. Under 6304, we just went over 6303, dealing with the C, 1, 2, and 3. Yeah, clearly golf course holes and that are not, but they are shown under 6304, are they not? It does have parking requirements under 6304 for those.
As does
because
residents.
The code doesn't state it that way, and this has been modified. It still shows parking for that.
As does.
And you would assume that you would need parking to meet that. Or would you not?
Are you done?
I'm sorry, go ahead.
Yes, there is a parking requirement. It's actually a parking ratio for golf courses, as there is a parking ratio for restaurants.
Right, and it doesn't, but it also shows for dwelling units and all that. And that's not explicitly exactly right. It isn't stated in 6303. Okay? However, it's still a parking requirement there. But where do you show restaurant outdoor space in there as a parking? What is the parking requirements for outdoor restaurants?
Right there.
Where? It
Restaurants.
says floor area. That's not floor area. So therefore, it isn't. You can't make that calculation. Now, I'm not saying this is the greatest written code, but I think it's very clear when you look at that, don't you agree, that that isn't floor area? So how do you come up with the calculation if you don't have a calculation?
Well, I don't think you can come up with an exclusion of the area, because outdoor uses and sales displays are governed by 6304. Why would we be pointed to 6304 if there were no requirements for outdoor dining? And why is C2, outdoor dining and retail displays, specifically mentioned in 6302D, and parking requirements mentioned as being exempt? Why would you?
Were you at any of the workshops?
No.
Well, the reason for that, and I'll just point it out, it was basically to allow this was occurring at all the restaurants. And we wanted to give the people an opportunity to do that without having to go through a lot of rigmarole. So that was explicitly put in there. In fact, it was even more square footage at one time. And the intent was that these areas could be easily enclosed, there would be floor areas, they would use plastic and everything in this climate. So there were a lot of reasons why it was done. For not being at these workshops, this was the kind of discussion we did. So you're making suppositions.
Yeah, but I'm looking at the statute.
And if you wrote the code?
I'm looking at the statute, and I'm looking at what the statute says, not what Mr. McGarry says. And what Mr. McGarry says, for the most part, is hearsay, because you don't have anybody here from the Planning and Zoning Board to testify. We've already shown a video clip of your answer to Tracy Carroll's question about outdoor dining. That was clear as mud, as far as I could see. And I can see, sitting on one of these boards, how I would be totally confused by what you were saying that the requirement is. You know, I would like to, if I was at one of these hearings, at least get a copy of the statute to make my own determination of what the code says.
Mr. McGarry, could
Yes,
you
sir.
define floor area as it is defined under Chapter 60 so we are all seeing from the same hymnal here?
Well, let me get.
Take your time. We have time.
Well, I had it all set out
No,
to
take
answer
your time.
that, and I apologize. Under Chapter 60, floor area. Floor area should be determined by measuring the outside dimensions of all enclosed floor area under roof, excluding garages, open and screened porches, carports, terraces, and patios.
It's 60 what? 60.0?
Yeah, it's the appendix, Chapter 60.
Mr. Lauer?
Yes.
Go ahead,
sir.
Mr. McGarry, you further cross-examination?
Let me see. What else? Did I have anything else on there? No, that's it.
All right.
Like to call Lori Conley, please.
Hello, I'm Lori Conley, LaurieConnelley. I reside at 3010 Nassau Drive.
Ms. Conley, did you appear at the Planning and Zoning Board meeting where this exception was, or this site plan was approved?
Yes, I did.
And could you summarize for council what your concerns were at that meeting?
My family owns the Petite Shop. We own the building in Sexton Plaza, and Dee Dee Shoe Salon. We own the building of Dee Dee Shoe Salon. My grandparents built the building in 1952, and it has been in our family since then. Our concerns is what's happening in Sexton Plaza, and a lot of problems on Saturdays, is we have a real problem with parking. And my dad, who's sitting over there, his customer is 55 to 65, and they are not going to park 4 blocks from the store to get to the store. There is no parking in Sexton Plaza anymore. And it is outside seating, it is employees, and it is the beach. It's a combination of a lot of problems. When I came to the meeting, I was under the assumption that this was an additional proposed outside seating on top of what Mulligan's already had. So that's what upsets my family, because we already have a problem in Sexton Plaza, and we're adding parking, more parking issues with the expansion of Mulligan's. I came to that meeting and found out that it pretty much had already been passed without even us knowing about it.
And did you take some pictures of Sexton Plaza and Ocean Drive recently?
I did. All of those pictures are from me.
Okay, could you identify this picture that's up here now?
That is right in Sexton Plaza, and I pretty much drove down from the spires around Sexton Plaza to Humiston Park, not finding one parking spot on a Saturday.
Okay, and I've got this marked as Exhibit I.
Okay.
Is that Exhibit I a copy of the picture you took?
Yes, it is.
Okay. Next picture. Did you take this picture?
I did. That was on the same day.
And can you tell us what the significance of this picture is?
You are not allowed to park in that parking lot, and I did pull in because I was told by the owner of Mulligan's that day that you indeed could use Holiday Inn parking lot to go eat at Mulligan's. I pulled into the parking lot and walked up to the front desk and asked if I could park in the parking lot to go eat at Mulligan's, and they told me absolutely not. I would be towed. That you had to have a sticker in the front of your car to park there. It was for Holiday Inn guests only. So my point was, this parking lot is sitting empty where my dad, who is in Sexton Plaza, you can't find one parking spot to go shop in his store or Dee Dee Shoe Salon. So my point was, why should they be allowed to take our parking spots, but we're not allowed to park in the Holiday Inn parking lot?
And when was this picture taken? That
was actually a Saturday on Labor Day weekend.
And have you been by the Holiday Inn parking lot since then?
Yes.
Are the same barricades and sign up?
Yes.
And I believe that was marked as, that is Exhibit J. It's on the back.
Yes, J.
Okay. And that's a true and correct copy of the picture you took?
Yes.
And if you look at Exhibit K. Is that a copy of a picture you took?
Yes, K.
And could you identify that location, please?
That is Ocean Drive, right in front of Costa de Este. Wait a minute, yes.
How about that one?
That's Humiston Park.
And which exhibit that's marked as Exhibit K?
That is L.
L. And is that Exhibit M?
Yes, that's M. And that's Sexton Plaza. And that is the middle of summer. And that's how it has been pretty much every Saturday, because I go down about every Saturday to check out the parking situation down there.
Okay, I have no further questions of this witness.
Counsel, do you have any questions, please?
Just one question. Ms. Conley, I saw your picture of Holiday Inn parking lot. Would it be an accurate statement for me to say that your question is why should the Holiday Inn parking be counted for Mulligan's if Mulligan's is not
Correct.
allowed to park there?
Correct.
Okay, so that would be.
I was under the assumption that because the owner of Mulligan said that you could park there. Okay. So I just wanted to verify that fact when indeed you cannot.
Okay, thank you.
May I cross-examine?
You may indeed. Cross-examination, please.
Oh, the first thing, you pointed out about your parents' place, about our parking lots, our parking spaces being taken. What spaces are these?
We have no parking.
You have no parking?
Well, we have, 4 spots in the back of the petite shop?
How big is your shop?
3,000.
3,000 square feet. Again, the math would show that. All right.
So the customers have no place to park. We used to have, we had Sexton Plaza was for the merchants also, not just for restaurants.
But it was public parking, hasn't it been for a long time?
It has been public parking, yes.
All right.
Got recross. Are you applying for a site plan application?
No.
No more questions.
All right. Further questions of counsel and Mr. Lowry? You can proceed with your case, please.
Done?
Yeah.
Okay.
This is just a summary. Although Mr. McGarry doesn't think this is relevant, the statute says otherwise, that the site plan application needs to take into effect the property rights of the adjoining property owners. It defies logic that a restaurant located in Vero Beach that already has a significant problem to nearly double its serving area without a significant increase in the parking requirements. And to allow this type of development, especially an after-the-fact approval from someone who built and then came back afterwards and asked for approval, sets a very dangerous precedent for our city. And once again, I want to summarize the reasons. There's not just one reason. There are 5 different reasons. Number one, you've heard testimony here today that the notification of this meeting was lacking. There were property owners who specifically asked for notification that didn't receive it. The notification itself was misleading. In fact, what it says is that it's a proposed addition, and in fact, the staff report later says it's an after-the-fact approval. Secondly, the staff's interpretation of the statute is inconsistent with the statute itself. There is no statement in this statute that outdoor dining is exempt from the parking requirements. There's a convoluted argument that since restaurants are computed based on square footage or floor area, that they are exempt. So you have to back into that interpretation. And it's especially disturbing when you look at the wording of the statute that deals with outdoor dining under cover, and it specifically says that outdoor dining under cover is exempt. Why would you have that kind of provision for outdoor dining under cover and then have a totally different type of provision for outdoor dining that's not under cover? it would be very easy for this council to change that statute to make it, and if that's your policy, if that's a policy you want to set, it's very easy, as the court noted in the second DCA, you can change the statute to make it say what you wanted it to say. Apparently at the hearing in which you adopted this ordinance, which, by the way, was a 5-minute hearing during your budget time, in which there were like 3 or 4 questions that were asked. The only significant question that was asked was by Tracy Carroll, and I didn't understand. I've listened to that video clip a dozen times, and I have no idea what Mr. McGarry said in response to Tracy Carroll's concerns about a total exemption and the application that was made by Panera. It seemed to me that he thought that it could be limited, and why it wasn't limited or why it was is really not relevant. The relevant thing is that I don't think the City Council or the Planning and Zoning had a copy of the statute. They didn't have a copy of the ordinance itself. They weren't allowed the opportunity to make their own decision as to what the ordinance says. They relied on Mr. McGarry. And as council knows, you just recently had a situation that went up the city to the circuit court, where the circuit court denied the Planning and Zoning Board's or the city's application to the circuit court for an appeal of the the code enforcement. And Mr. McGarry's interpretation of that statute did not stand up to legislative muster. So I think the same is true here. This is a dangerous precedent to set. This city has been given 5 different ways that this body has been given 5 different ways that it can set aside the decision of the Planning and Zoning Commission, and I certainly hope that you take that opportunity. Thank you.
Mr. Comment, now there could be cross-examination of Mr. Lauer, or do we move on to the other side of the issue?
I'd be happy to answer questions or be cross-examined. I'm fine.
Cross-examination?
Right. I don't know if you were making a summation or...
That was a summation, but
okay.
If there's any other questions, I'm happy to answer questions.
Well, are there questions then from the floor of Mr. Lauer?
Or if there's any presentation by the public, too.
Any presentation by the public on that side of the equation? Okay, I guess we move to the other side.
Okay.
Is that correct, Mr. Comment?
Well, I don't know if the appellee in this case would be Mulligan's or that property owner. And
may I have a second, please, before we start? Because I'm going to have at least one witness.
Okay.
For the appellee. Just want to clear it.
But witness, I'm sorry, just a point of order here. What witness as to whom? As to
are you
a Planning and Zoning Board member?
Okay, but Mr. McGarry, are you rebutting what Mr. Lauer said, or are you making it as a presentation?
Mr. Lauer said there's no Planning and Zoning Board member here. I have a member of the Planning and Zoning Board.
Okay, so you're rebutting.
Right.
Call your witness forward, please.
Excuse me. What I said was that no members of the Planning and Zoning Board testified here today, and that all of what Mr. McGarry said about the Planning and Zoning Board meetings was hearsay that should not be considered by the City Council. I did not say that no one was here.
I believe the record that's in the record.
Okay.
The verbatim
Okay, you
minutes.
may call your witness, Mr. McGarry.
I'd like to call Mark Mucher.
Mark Mucher, 617 Indian Lilac Road, member of the Planning and Zoning Board. I'm not a lawyer, but I was admitted to law school. So, I was going to speak on my own, and I'd be glad to answer any questions, but I took offense to a number of things that went on here today. First of all, that I believe you did say there was no member of the Planning and Zoning Board here, and that the tape will prove that. But bigger than that, I think the appellant was treating members of the Planning and Zoning Board as lemmings who would follow whatever Mr. McGarry says. And I think if all of you have been to a Planning and Zoning Board meeting and seen that that's probably the farthest thing from the truth. I mean, we we like to give them a hard time, if nothing else. I also thought it'd be useful for me to testify why I voted the way I did, and I was with the majority. First of all, I voted the way I did because although there was confusion in the notice, they were not adding anything. In fact, the operation had been in place for well over a year, maybe as much as 2 years. And that not approving their application would require them to tear out their outdoor dining and cease altogether, which I didn't think was correct. I mean, I'm not a big fan of after-the-fact approvals, but it is what it is. But the biggest reason I think I voted for approval was the fact that this, and I think it's been presented inaccurately. This whole argument is presented like this additional seating is all overflow. And there was testimony during the Planning and Zoning Board meeting that it was not overflow. Oftentimes, if the outdoor seating conditions were correct, were right, favorable, and that people were dining outside, then there would be empty seats inside. So it really doesn't have anything to do with the parking, if you look at it that way. I understand there's a parking problem in the area, and there's a number of different factions that are working on that, and everybody would like to see that improved. No question. And finally, before I answer any questions, if there are any, I'd like to remind you all that one of the big items in our vision plan of, God, how long ago was it, 10 years, was the encouragement of outdoor dining. So that's all I had to say.
May I question my witness?
You may indeed. Proceed. It's your case.
Mr. Mucher, you heard my testimony today on the application of the parking standards for exempting outdoor dining?
Yes.
Do you believe that? Did you understand that when you recommended approval of that ordinance to the council?
I understood it. I didn't pour through the code to the extent that Mr. Lauer did, but that has been my understanding for a long time. Yes.
So that's your understanding of it? And you understood that at the last planning zoning meeting on this site?
Yes, nothing changed.
Right.
Mr. Lauer, any questions, comments?
Mr. Mucher, did you at the conclusion of the Planning and Zoning Board meeting say, I believe that they're in full compliance, Mr. Chairman. We don't have a choice even if we want one, so I think we ought to move forward unless someone else has some comments?
I believe I probably said that, yes.
Okay, I'm going to give you a copy of Exhibit H. And by the way, I'm very happy that you're here today so that you can verify that that's what happened at the end of this meeting. And then Mr. Coy said, Cahoy said, I'm prepared to vote, but I think that until that signage at Holiday Inn is dealt with, I don't think our problem is solved. I don't think I can vote for this being in compliance. Do you remember him saying that?
Yes.
And then Mr. Lofter saying, any comments?
Yes.
Mrs. Misuse asking Mr. McGarry, can you respond to that?
Yes.
And Mr. McGarry saying, well, again, I get back. I don't know if that is germane to what we you're looking at right now. I mean, it's an ongoing problem, if it's a problem. We've had conflicting testimony whether people can do it or not. I mean, the main issue we have here is whether this outdoor dining meets, and he believes it does. I mean, that other issues I think should be discussed later as part of this group getting into that thing with employees. So the staff sticks with it, with its recommendation. Remember him saying that?
I don't know if it's verbatim, but yes.
Okay, and then Mrs. Misuse asking Peggy, who I believe is Peggy Lyons, do you have any comment on that?
Yes, and it's Manus and Lion, not Lions.
Okay, thank you. I guess that's almost like lower rather than lower. And then Ms. Lyons saying
compared to how you spelled it.
Mrs. Lyons saying, what I think your planning director is saying is that because there is no parking requirement for outdoor parking, and that's what's in front of you in the site plan application.
Yes.
And Ms. Misuse saying, right. And Mrs. Lyons saying, it's not a variance, it's a site plan application, then it's not germane. What is to be germane is the overall parking for the overall Mulligans, not the outside dining, which is an entirely different issue as I understand your planning director.
That's not on Exhibit H. It sounds like she might have said that.
Okay, thank you.
All right, Mr. McGarry, anything further?
Actually,
I don't think
Mayor, I believe the FOE wanted to say something.
Yes, I'm good. We're going to get
Okay.
there. The appellee, would the appellee like to come forward and present?
He declines that. If you have any questions of the appellee, would come forward.
I have a question, yes.
Okay.
I'm sorry, I had one more thing I wanted to add, if that's all right. There was some question as to whether Mulligan's or Mulligan's employee parking was allowed in the Holiday Inn, and there was testimony by the owner of Mulligan's. There was no representation from the Holiday Inn, but I think what we heard today was that Mr. Hart testified that there was permission, but it certainly wasn't the owner of the Holiday Inn. It was the desk clerk. Announcing that policy. So you may want to get that clarified. But again, to use a popular word, I don't think any of this is germane.
Just for the public, Mrs. Turner has a matter she has to attend to, so the four remaining of us will proceed. Ms. Graves, if you would like to.
Can we take a 5-minute break before we get
indeed.
into
Would
the
you like
appellee?
Let's discuss the timing of this. I mean, we could press on we could take a break until 5 minutes before the hour and then press on to 12:45 and see where we get, and then we'll have to take a lunch break, I think.
Okay. Sounds good.
So we're going to recess until 11:55, which is 12 minutes from now.